Welcome back to Contracts Part 3, and in this part we're going to do the last half of the general terms and conditions, or again, what some people refer to as the boilerplate. We see paragraph 13, patents and royalties. All royalties, license fees, and other charges are your responsibility. Now, you might think royalties aren't going to be that important, but I do draw your attention. Once again, license fees could be a critical issue, so be sure you're licensed to not only perform work in the area in which you're working, but also licensed to put in place the material and equipment you're putting in place. That can be a factor. And recognize you are the sole responsibility for doing that. Paragraph 14 deals with injury or damage to persons and property. Now, we're going to talk about workers' compensation in a moment, but you're expected to have in place the insurance necessary to protect you, the owner, all other parties involved in the project in relation to what is dealt with in the variable part of the contract. So injury or damage to persons and property that is your responsibility is very important. Then you talk about labor conditions in paragraph 15. Let me just say, drugs, alcohol, prejudicial actions related to race, gender, ethnicity have no place in our industry. And this is a paragraph that will strictly be enforced, should be enforced, whether it's from the owner to the general contractor to the subcontractor, or subcontractor to subcontractor. Paragraph 16, responsibility for work, title, and limitations on use of property. This becomes very important, particularly, again, if you are on the project early on in the project. When is your work accepted? When are you responsible? How long are you still responsible for working or maintaining the equipment that you install? So be sure you understand that paragraph because it is very, very long. Reread it several times, particularly before you leave the project. Then paragraph 17 talks about insurance and bonds. We have chapters related to insurance and chapters related to bonding, but we noticed in here there was no bond in this particular subcontract with the general contractor. However, is there a bond in the overall project between the contractor and the owner? This could be very important for you, particularly if it's a payment bond. If there's a payment bond and you're not being paid, you need to know the notice requirements related to that bond so that you can go against the bond if you're not getting paid. This is an important aspect of construction, is knowing when to give notice on bonds. It's also important to know when to give notice related to insurance. If you have an accident and don't report it, you may not get compensated for it. Now, paragraph 18, speaking of compensation, talks about compensation, inspections, and payment. And once again, we have to recognize that just because we've done it doesn't mean we're going to get paid for it. It has to be inspected, it has to be approved, and then the whole process for being paid has to go through. Submittal of a payment request approved, owner pays, then the contractor pays you. One of the things that you have to recognize is based upon this paragraph 18 and also based upon the variable payment terms within the contract that we discussed under why we're doing this, is a basic issue called pay when paid or pay if paid. And this is an important aspect for the contractor for cash flow, but it's also a very vital aspect for subcontractors and subcontractors. How far they are removed from payment terms, how far they are removed from being paid is vital to your cash flow. So know these conditions and make sure that they're conditions that you can abide with and comply with. Paragraph 19, unemployment insurance and taxes. As I said, this is a special type of insurance, but one of the reasons you have unemployment insurance is so that if you as a subcontractor have an employee that gets hurt, that employee isn't going to sue you. That employee is going to make a claim against unemployment insurance. However, this paragraph is making sure that you, the subcontractor cannot have your employee sue the contractor for damages. Generally speaking, legally, an employee injured under a subcontractor's employment can't sue the subcontractor, but could sue the general contractor. This paragraph is your requirement to indemnify the contractor. We'll talk about that further in workers' comp insurance. Taking over performance and termination of the contract. Let's hope this never happens. But if you're given a 48-hour notice by this contract, many contractors make it a 72-hour notice. Basically what this is doing is someone's going to take over your work, and any costs related to doing that work is going to be charged against your account. You will not get any payments until all the work is properly done. And that very well could mean that you won't get any payments at all. In fact, you may be sued for additional costs that the contractor suffered. So be aware of that. It's a unfortunate situation, but it does happen in our industry that contractors terminate subcontractors. Sometimes owners terminate contractors. Paragraph 21 deals with warranties. And this is very important. Again, depending on when you leave the job, when does your warranty period start and when does it end? If the warranty period doesn't start until final payment by the owner to the contractor, you may have been off the job for 6 months, and your equipment now has to be warranted not just for a full year, but perhaps 18 months since it's been working. So be aware of that. Make sure the warranty and you are in agreement. Paragraph 22 deals with laws and regulations. This is a catch-all, but you have to be responsible for laws and regulations that you may never have read. But neither has the owner perhaps read those. Neither has the architect. Neither has the general contractor. And then some inspector comes on the site and says, you are responsible for this. It's tight, it's tough, but that's the way it is. Everyone down the line has basically signed the same issue. Paragraph 23, notices. Again, notices are so important, you have to pay attention to them. I would recommend you make a cheat sheet of all the notices that you have to do and what the time frames in which you do them. But don't disregard putting anyone on notice that may be for a delay, it may be for a change, whatever it is. Now in paragraph 24 we talk about arbitration, and basically that is how a dispute that can't be settled amicably on the job site or in offices or whatever else are going to be settled. It's not going to go to court, it's not going to go to a mediation in this case, but it is going to go to arbitration, and the arbitrator or the panel of arbitrators will be the final determination of how this dispute is settled. Paragraph 25 talks about non-assignment. This is very difficult because you will probably, as a subcontractor, sub to another contractor. Basically, this is saying you need permission to do that. It's probably not going to be withheld because you're going to sub it to somebody that is going to be important. What is in paragraph 26, subcontract includes the entire agreement. Think about this for a minute, and that, although a very small paragraph, is telling you nothing you said, nothing you did prior to this subcontract has any bearing on what we expect you to do. In this subcontract, only what is written is what is expected. But if you had some sort of understanding before you entered into this contract, if it's not in writing, it's not part of the contract. This will be upheld in arbitration, it would be upheld in courts. It's always been the case that anyone trying to look at a contract only looks at what is in writing, not what people said they said before they got to this point. And then paragraph 27, this form of the subcontract and these general terms are designed for general use in any of the states. But if there is a law or some regulation that is contrary to, then the law or the regulation of the state is obviously going to govern. Now, let me tell you, and again it says, sign, date, and return both copies to R.S. Cook & Associates, Inc. If any changes were made to that, we had to take it, we had to eliminate those changes, send it back, and have it re-signed. It's a tough subcontract. There are many provisions today that we've changed and make it easier, particularly if you're using consensus docs as your subcontract. But I want to say, at this point, one of the most important factors in dealing as a contractor is the rapport you have between contractor and subcontractor, subcontractor and subcontractor, or contractor and owner. It's the rapport you have. As difficult as these conditions are, generally speaking, they're going to be used only when you have a real problem. If you're all working together and you're all moving forward together and making this thing happen, we're going to have a much better relationship, a much better rapport on the job. Nonetheless, as a contract administrator, know the details and don't not perform in accordance with those details. If you can after that, have a good time.